Do you smoke weed? Do you own a gun? If you answered yes to both of these questions, then according to the Department of Justice, you're violating federal criminal law. But the United States Supreme Court appears to disagree. Here's the background. A federal law that was passed in 1968 makes it a felony for anyone who is an unlawful user of a controlled substance to possess a firearm. Because marijuana is still illegal under federal law, that means that regular marijuana users can be prosecuted just for having a gun. The case that's now before the Supreme Court involves a Texas man who admitted that he had used marijuana and was later charged after federal agents found a handgun in his home. Lower courts threw out the case, saying that the federal statute violated the Second Amendment. During recent oral arguments, several of the United States Supreme Court justices appeared to be extremely skeptical of the government's position. They pointed out that several of our founding fathers were habitual drunkards and owned guns, including James Madison, who, according to Justice Neil Gorsuch, consumed a pint of whiskey each day. If the court strikes down the federal restriction, that decision could affect millions of Americans who legally use marijuana under state law, but risk a federal conviction if they also own a firearm. The Supreme Court's expected to release its decision later this year. Follow me for more updates on this and other important cases.